Good morning, good afternoon, good evening, wherever you are joining us from. My name is Jess Peake, and I'm the Director of the International and Comparative Law Program at UCLA School of Law. I am also on the board of the International Law Students Association, ILSA, one of the presenters of this event today, along with Jessup Ukraine. And we would like to thank our Ukrainian Jessup friends for collaborating on this, despite everything they are currently facing. We are here to discuss Russia's invasion of Ukraine and the implications for international law. And to do that, we have four leading international law scholars to guide us through this conversation. I'm sure we're all very familiar with at least some of the events in Ukraine since the invasion by Russia on February 24th in violation of Article 2.4 of the UN Charter. And so I won't take any time here explaining the context in which we are having this conversation. Instead, I will invite each of our speakers to give some opening remarks for about 10 minutes, which will leave us about 45 minutes for Q&A at the end. Many people have already submitted questions in advance, so thank you very much for that. You can also submit questions during the panel using the function at the bottom of your screen, either on Facebook or YouTube. Unfortunately, we won't be able to get to everything, but we'll do our best to touch on as many issues of interest as possible. Our first speaker is Dr. Mykola Gnatovskyy at Taras Shevchenko National University of Kyiv, Ukraine. Dr. Gnatovskyy was also recently appointed as a judge to the European Court of Human Rights, and unfortunately, Dr. Gnatovskyy will need to leave us shortly after his remarks. Next, we will hear from Harold Hongju Ko, Sterling Professor of International Law at Yale Law School. Following Professor Ko will be Philippa Webb, Professor of Public International Law at King's College London. And our final set of opening remarks will be from Dapo Akande, Professor of Public International Law at the University of Oxford and a member of the International Law Commission. With that, I invite Dr. Gnatovskyy to take the floor.
Thank you very much, Jess, and hello to everyone. Thank you very much to ILSA for organizing this event, and to my wonderful colleagues on the panel for joining me here, and also to all the Jessupers who have come here from around the globe to virtually participate in this event. And my sincere apologies for not being able to stay with you for the Q&A session. And this is due to some rather urgent travel that I have to undertake. In my remarks today, of course, speaking in my private capacity and as a professor of international law from the University of Kyiv, I would touch upon Ukraine's approach to using the existing domestic and also international judicial architecture in response to Russia's war of aggression against Ukraine. The war of aggression against Ukraine was started by the Russian Federation, as you, of course, are very well aware, in February 2014 with the occupation of the Autonomous Republic of Crimea and the city of Sebastopol, and then continued in the two eastern regions of Ukraine, in the regions of Donetsk and Luhansk. But it's true that it's only the new phase of this war of aggression, the full-blown war that started, the invasion that started on the 24th of February this year, that has actually brought the matter to the attention and to the top of the agenda of the politicians and also of international lawyers. And in fact, this is rather easy to explain, as this war is being waged by the Russian Federation in defiance of the basic foundational principles of international law. After Adolf Hitler, no one has ever attempted such a war in Europe, a war of aggression, a war aimed at the complete destruction of another European state. And that is why I think international law is really facing a challenge, whether it is to develop, whether it is to prove its relevance, or it will have to, well, we as international lawyers would have to think of another job perhaps, or at least of completely rethinking international law or alternatively going back to the state of international law prior to Second World War or even earlier, which appears to be ruling the kind mindset of the Russia's leadership. But as we are here in the company of Jessipers, of course, it means that everyone here believes in international law and international justice. And this is why I'm very happy to say that Ukraine has not lost its hope in international law and international justice. It has been traditionally rather positively disposed to the options that international law was giving, and it has been traditionally open to international adjudication on many occasions. But since 2014, and my wonderful colleagues here on the panel could also develop this, Ukraine has used various avenues that exist in international law to address various aspects of Russia's aggression. In the absence of an effective intervention from the United Nations architecture, particularly the Security Council, Ukraine had to concentrate on fragmented, separate issues, trying to create a bigger picture of the judicial response or the legal response to the war. Professor Ko will certainly speak about the International Court of Justice and the two cases that are there in front of that court between Ukraine and the Russian Federation. But certainly, of course, the mechanism of interstate applications to the European Court of Human Rights has been widely used by Ukraine. The International Tribunal for the Law of the Sea and the dispute settlement mechanisms provided by the United Nations Convention on the Law of the Sea were also involved, as was, of course, Ukraine's wish to have the situation scrutinized by the International Court, by the International Criminal Court, which led to Ukraine giving its consent to the jurisdiction of the International Criminal Court, covering all events happening in Ukraine since the beginning of the Russian invasion in 2014. However, there's the obvious issue with the existing international legal judicial architecture, and that is its inability in its current shape to address the core crime, the original crime behind everything else, which is the crime of aggression. Hence, the proposal to address this issue and to ensure that the existing substantive norms of international law can actually be operationalized and can be used in order to achieve accountability for the crime of aggression. I'm sure Professor Akande can speak more about this, and I've been privileged to participate in numerous discussions with him on these matter in the recent months. But there's one thing I would want to point out in this respect. One can argue about the war crimes and other atrocities that are being committed during the conflict. They have shocked, of course, the conscience of the mankind, and they have places like Bucha and Irpin and currently Mariupol are not going to be forgotten for decades. That's for sure. But it's also very important that we see the origin of the war as being completely criminal and unlawful. And any act, even if some of those acts can be seen as being compliant with international humanitarian law, with the law of armed conflict, i.e. they are some of them might be targeting military objectives, and some of them might be proportionate in the sense of additional Protocol 1 to the Geneva Conventions. Nevertheless, they are still criminal because they are crimes. This is a continuation of the crime of aggression, which is a continuous crime. It doesn't stop after the decision to invade a foreign country. It continues with every hostile act that is being undertaken in this context, and that's why the efforts to set up a special tribunal for the crime of aggression against Ukraine are extremely high on Ukraine's agenda. And this is something that has recently been fully endorsed by the Parliamentary Assembly of the Council of Europe. And there's a hope that, there will be a further work about this tribunal that will bear fruit. Let me also take this opportunity to speak about the domestic judicial response and the domestic architecture. And here there's also two tracks. There's the track of accountability for core international crimes, and investigations have been launched by Ukraine, also in the format of a joint investigation team with a few other European states, a joint investigation team that has, for the first time in the history of such arrangements, been also joined by the Office of the Prosecutor of the International Criminal Court. And that addresses war crimes, crimes against humanity, and potentially the crime of genocide in Ukraine. But also there's domestic prosecution for the crime of aggression. And if the special tribunal proposal is going to progress, it would mean that Ukraine would certainly be delegating some of its jurisdiction over this crime to a special tribunal. Another track is the reparations track, and reparations is very much on everyone's mind. And as long as Russia, despite being completely defiant of international law, despite violating its very foundations, is still somehow integrated in the international community, there's hope that the claims, the reparation projects might also produce a result. And in this respect, I think one has to follow very closely the developments around the principle of and discussion about the sovereign immunity of states, whether it is applicable, whether it can be disregarded in the context of sanctions and countermeasures taken by Ukraine, but also by other members of the international community against the Russian Federation for its violations of erga omnes obligations. And in this respect, I would like to draw your attention to a relatively recent judgment of the Supreme Court of Ukraine on the 14th of April this year, in which the Supreme Court ruled that Russia's sovereign immunity can no longer be invoked in cases involving damages caused by Russia's aggression against Ukraine. This has potentially very far-reaching consequences, especially when it comes to the implementation of this decision, of this judgment, and this whole line of judgments, both domestically in Ukraine, but potentially also internationally. And I think this can also be seen as at least a question to the Supreme Courts of other European and also Western states, and actually everyone in the world, who belong to the responsible members of the international community upholding the international rule of law, whether the principle of sovereign immunity can actually be invoked in the case of the aggressor state. Let me once again apologize for not being able to continue for a long time being with you. I will be with you virtually for some short time, but unfortunately I will have to leave. Thank you very much for your attention, and I will certainly be then watching this event after it completes, because I'm sure that the contributions from the distinguished panelists are going to be extremely important, as will be the questions and answers session. Thank you very much for your attention.
Hello, this is Harold Coe from Bruges, Belgium. Let me say first, congratulations to all of you who have done the Jessup. I know that while you were doing it this year, you were undergoing a bit of a existential crisis, because at the same time that you were doing the moot court, the Ukraine crisis was breaking out in the newspaper and on the media, and you were watching it every day. And I'm sure you were asking yourself the Tina Turner question, namely, what's law got to do with it, and what's law but, in this circumstance, some sort of sweet old-fashioned notion. What I think the panel today is supposed to suggest is that international law gives you a special lens into this crisis in three ways. It helps you to evaluate the crisis. It helps us to address the elements of the crisis, break it down, figure out what to do next. And hopefully, third, it will help us solve the crisis and return to a situation of peace, security, and stability. So how does it help us evaluate? On February 24th, as you know, the Russians, led by their President Vladimir Putin, began to invade Ukraine. They had been operating there since 2014 in the Donbass and had also occupied Crimea. What's interesting is that Putin has throughout asserted that he's not violating international law, that law is on his side. He says that he's preventing a genocide being committed by neo-Nazis against the Ukrainian people, and that for that reason, he needs to intervene to prevent and punish the crime of genocide under the Genocide Convention. He further denies that he's committing more crimes, and he certainly denies that he's committing genocide. His claim is that he's responding to a provocation from Ukraine. Well, international law helps you to evaluate these claims. His claims are false. They're false as a matter of fact, and they're false as a matter of law. But what's interesting is that he wants to be on the right side of international law, even in the middle of this crisis. So how do you address the crisis with international law? Think about this as developing a political and diplomatic strategy, and then developing a legal strategy that supports the political and diplomatic strategy that leads to a stable solution. And let me suggest that there are 5 elements of the strategy, all of which are affected by international law. First, information. We are living through a human rights crisis. What's more important than anything else is for everybody to have accurate information about what's going on, and for the perpetrators of the international law violations not to be able to hide this through disinformation campaigns or other means. International law favors the free flow of information. There's been extensive work on why disinformation is in violation of international law. And we've had an unprecedented flow of information about what's going on in Ukraine, in major cities, and why the justifications being given by Putin to his own people are false. The second element is illegality. It's very important, given the evaluation that I suggested, that these actions be branded as illegal by as many legitimate law interpreting organizations as possible. That's what the judge was just referring to, because someone who is an outlaw is isolated in an interdependent world. That leads to the third element, isolation. The goal of pervasive declarations of illegality is to make someone isolated. And the longer that someone is isolated, the less they are able to exercise influence, the more likely it becomes that they will have a weakened bargaining position and that they have to figure out what to do. Putin is caught not just in a web of lies, but also in a web of illegality. And increasingly, that's making him someone who has less and less leverage. He is in the same situation as Pinochet was back in the day. He's been branded an outlaw. This opens the door to enforcement by many different organizations, about which we'll say more. It strengthens the basis for sanctions, and it lays the groundwork for the next step, which is diplomacy. If Putin believes that he is losing leverage, and the reason for that would be because his allies are being scared off, particularly China, from supporting his campaign of atrocity and aggression, the more likely it is that he will seek a non-military solution at the end of the day, particularly if the Ukrainians resist valiantly, as they have been doing in place to place. And so the next step will be diplomacy. We don't know exactly where it will occur. We don't know exactly who will moderate it. We don't know exactly who will be at the table. We don't know exactly what kind of deal will emerge, but we can hope that it looks something like the Dayton Accords, which ended the conflict in Bosnia, which leads to the final element, accountability, that diplomatic solution preserves both civil and criminal accountability, as occurred during the Bosnian conflict. Both Slobodan Milosevic, the leader of the Serbs, and Radovan Karadzic, the leader of the Bosnian Serbs, signed off on a deal, but they ended up going to The Hague, where Milosevic died and where Karadzic is currently essentially imprisoned on a life sentence in a prison in Scheveningen. So all 5 aspects of this strategy, information, illegality, isolation, diplomacy, and accountability, are fashioned and shaped by international law. So then the question is, what will the solution be? The solution, hopefully provoked by legal actions and lawsuits, as well as many other actions, which we can discuss, which are themselves lawful responses, can drive Putin into this diplomatic outcome and weaken his leverage so that he cannot demand accountability as the price of ending the slaughter. This relates now to the lawsuits that have been brought at the International Court of Justice, of which I've been involved with my friends from Covington and Burling and my colleague, Professor Jean-Marc Tubinin of Nanterre. Ukraine decided early that they would fight Russia on the court, in the court, and not on the battlefield as their primary locus. Obviously, they are fighting brilliantly and courageously, but they initiated their own full court press back in the mid-2010s. They filed a case at the International Court of Justice, a case under the Law of the Sea Tribunal, several cases before the European Court of Human Rights in Strasbourg. They asked the International Criminal Court to open a preliminary investigation. They filed a trade and transit case versus the World Trade Organization, and numerous international commercial arbitrations about expropriation of Ukrainian assets in Crimea owned by Naftogaz, Oshad Bank, Privat Bank, and others. The first case that we brought, our team, was in 2017, which had 2 elements, challenging the financing of terrorism in the Donbass, as well as the shoot down of the Malaysian airliner MH17. And then secondly, challenging pervasive racial discrimination by the Russian occupation in Crimea. On that case, we won provisional measures, we won preliminary injunctions, and we've just filed our memorial on the merits. But then in the beginning of this year, when Putin again began to spread his lies again, we thought there could be a basis for a second suit about allegations of genocide. And this could be brought simply under the Genocide Convention, which allows countries to bring contentious actions against each other about interpretation, application, and fulfillment of the terms of the Genocide Convention. As you all know from doing the Jessup, there's a requirement that there be a dispute. And in fact, there are 2 disputes. There's a factual dispute. Is Ukraine, in fact, committing genocide in the Donbass or in Crimea? Ukraine obviously says no. That is Russia's claim. So there's a dispute about the facts. And then the second is whether Russia has legal authority, therefore, to use military force, including murdering civilians, as part of its legal duty under the Genocide Convention to prevent the crime of genocide. And obviously, Ukraine believes that this grants no legal authority to Russia under these circumstances, and indeed that every country that's a party to the Genocide Convention has a right to a good faith interpretation of the convention and the facts. With this in mind, we filed an application and a request for provisional measures. As you know from your Jessup work, provisional measures have been issued in as few as 3 days. We ended up getting an order in 9 days on March 16th, 2022, by a vote of 13-2. The Russian and Chinese judge only dissenting, the court held that Russia shall immediately suspend its military operations in the territory of Ukraine, and by a vote of 15-0, the Russian and the Chinese joining the majority, that Russia shall not aggravate or extend the dispute, for example, by using chemical weapons or hypersonic weapons. What's interesting is how many commentators responded to this by saying the International Court can't enforce its own rulings. As law students and lawyers, you know, no court can enforce its own rulings. No court can enforce its own rulings. But when there is a declaration of illegality of this nature, everyone can enforce the order and further isolate the outlaw. It's a strategy of outcasting. It's a strategy of rejection of Russia's claims. It strengthens the case for sanctioning. It strengthens the case for seizing Russian oligarchs' assets. It strengthens the case for cutting off access to oil imports and to financial transfers and the SWIFT banking system and to semiconductors and the rest. So every country and every international institution can now step forward to enforce the court's order, stop Russia's aggression, sanction the perpetrators, and then try to bring them to justice. In the oral argument on provisional measures, I said, and I think it's a good summary, Putin's short game is force, the world's long game is law. So this resolution can be brought to the UN Security Council. It can be brought to the UN General Assembly under the Uniting for Peace resolution. Notice that the provisional measures order itself is binding. You know this from the Legrand case. It can be used to keep China neutral. President Biden told Xi Jinping that if he was to provide military weapons to the Russians, he would also be in violation of the International Court of Justice order. And it can, again, make Putin and his cronies more isolated. They can't leave their country. They can't take their assets out of their country. They can't move their yachts and all of the consequences that we've seen. So with regard to accountability, there are many mechanisms now being pursued and discussed. We'll hear more about them from my colleagues on the panel for potential criminal and civil accountability. And I think we all favor a robust accountability process and the gathering of evidence as atrocities are occurring every day. Let me just conclude with two thoughts. The first was by President Bill Clinton upon hearing of the death of the late Madeleine Albright. He said simply, she thought that the Ukrainians could prevail if we just stick with them. And I think that's a brief but accurate summary of what the strategy and solution is going forward. The second goes to Jessup and the Ukraine. On March 2020, just before the pandemic hit, it was literally a week before, I was invited to Ukraine to judge the Jessup moot court. And I met a young woman, Tata Marharian. I don't know if she's on the call. I hope she sees this. She's a brilliant international law student who said she had studied international humanitarian law, but was wondering, now working in full military uniform at a hospital, watching dying children, whether international law is really answering the concerns of her generation. And one of the reasons that we filed the suit was for Tata and her colleagues to answer that question. Does international law have a response? What I was struck by in the moot court in Kyiv is that it was the 25th anniversary of the Jessup moot court. And there in the competition, all 25 years of winners returned. And when I asked them what they were doing now, every single one of them was working on some kind of case against Russia in some kind of legal forum. They were, in effect, the international law army of Ukraine, fighting alongside their military army. And Tata put on Instagram a picture of this group and said, "Dear Mr. Ko, let us battle a little bit on the ground and we'll be back to the Ukrainian international law army soon." I should simply close by saying that this international law army is bigger than just Ukraine. It's every single one of the students on this call. It's every single international lawyer who's worked on these issues. This is a time in which our project, the post-war international law project, is under challenge. We must succeed in preserving this international legal order for the future. And the way to do it is to band together and continue to fight the long game of law against Putin's short game of aggression, atrocity, and force. That's what law's got to do with it. Law has everything to do with it. And we're all part of the international law army. Thank you.
Thank you. I'm Philippa Webb. I'm joining you from Oxford. During these troubling times, I've been given hope by the energy, creativity, and bravery of the younger generation, especially the Jessup Mooters I know, and now the story of Tata that you've just heard. And I'm very pleased to be here with you. Last week, the UN Security Council held an informal meeting under the ARIA formula that was convened by Albania and France in cooperation with Ukraine. And the aim of the meeting was to bring together member states and key actors involved in the documentation of crimes committed in Ukraine in order to identify how such efforts can be supported and coordinated so as to ensure the effective investigation and prosecution of those responsible for atrocities. That's taken from the concept note. Amal Clooney, whom I'm on the legal task force on accountability for crimes committed in Ukraine with, addressed that meeting and outlined 7 steps that states can take. And she noted that peace, like war, must be waged, and justice too is something we must fight for, words that very much chime with what we've just heard from Harold on the international law army. So I'm going to touch on the 7 steps that Amal laid out, but focus in particular on options regarding immunity, which has already been mentioned by earlier speakers. So the first step is for powerful states, including the United States, to support the International Criminal Court by dropping unprincipled objections to its jurisdiction and offering resources and evidence to support the prosecutor's work. So that was a step said on the 27th of April. And in the very same meeting, Ambassador Beth Van Schaack, who is the ambassador at large for criminal justice for the United States, expressed strong support for international investigations, including those conducted by the ICC. And 2 days later, Secretary Blinken said that the Biden administration is supporting the ICC war crimes investigation. So we're already seeing good progress on that step. The second step is that states must ensure that those responsible for the crime of aggression who are currently beyond the reach of the ICC can also be brought to justice before a court of law. And this point has already been addressed by Mykola Gnatovskyy, and I think Professor Akande will also be speaking to it. But simply to note that this is another piece of the accountability puzzle. Third, states should file interventions in support of Ukraine's cases against Russia at the International Court of Justice and the European Court of Human Rights. You've already heard from Harold about the actions being taken at the ICJ and the stunning success, I would say, of the case with the order on provisional measures before the ICJ. But this is just the preliminary stage. These cases will continue. And there's an opportunity here. There's already a legal framework that exists for other states to stand up and stand alongside Ukraine in these cases. So Article 63 of the ICJ statute gives states the right to intervene in proceedings where the construction of a convention to which a state as a party is in question. Nearly every state is a party to the Genocide Convention. And in another case before the ICJ, the Gambia-Myanmar case, the Maldives, the Netherlands, and Canada have announced their intention to intervene in support of Gambia's case that Myanmar is responsible for the genocide of the Rohingya people. And some states have already been indicating their interest in intervening in support of Ukraine in the Ukraine-Russia case at the ICJ and the European Court of Human Rights. And well-coordinated, focused, and pertinent interventions I think have great potential to be very useful in developing legal and, depending on the type of intervention, even factual aspects of these cases. The fourth step, and I must mention that even though I'm calling these steps, they don't have to be taken in sequence. They can be taken in any order. The fourth step is that the UN General Assembly should make clear that sovereign immunity should not prevent Russian state assets being made available to the Ukraine and its people, and that the assets of all those who support the war are at risk. And I want to go into this point in a little more depth. So currently there's $600 billion worth of Russian foreign currency reserves frozen in foreign jurisdictions, about half of that amount believed to be restrictions imposed on the Russia's central bank. Now, we know that immunity is a high bar. In 2012, in the jurisdictional immunities judgment, the ICJ said that customary international law requires that a state be accorded immunity in proceedings for torts allegedly committed on the territory of another state by its armed forces in the course of conducting an armed conflict. That was with respect to the bar to jurisdictional immunity. And as for immunity from enforcement, the court recognized that in general, state property is immune, subject to narrow exceptions such as express consent or when the assets are being used for commercial purposes. And national and international instruments on immunity also tend to show that central bank assets in particular have very extensive immunity from enforcement. But there are options for overcoming this high bar, and these are actively being explored by lawyers and scholars. And I'm just going to share 3 ideas with you. First, as Ingrid Wirth and Tom Royce, among others, have argued, immunity from jurisdiction and enforcement relates to judicial proceedings or acts connected to judicial proceedings. It does not appear to be a bar to the freezing of assets through executive action. And we have already seen some jurisdictions taking executive action with respect to state property. And legislative action that is not linked to a judicial proceeding may also be possible to freeze, seize, and repurpose frozen assets. Now, that doesn't mean no legal regime applies, even if we're outside of the immunity context. There may be rules around inviolability, sovereign equality, due process, possibly expropriation that need to be considered, but they're not insurmountable. Second, any action against state assets that's at first unlawful could potentially be justified as a third-party countermeasure or an act in collective self-defense. And in this regard, I would refer you to a op-ed published by Professor Tuvena, who, as Professor Coe mentioned, is part of the Ukraine team before the ICJ. And on the 2nd of May, he published this article suggesting that the Ukraine, the United States, Canada, France, and other like-minded states could conclude a treaty waiving the immunities of Russia with respect to claims by Ukraine and its people for damage caused by the war, and that this would be justified as a measure of collective self-defense and also necessary and proportionate. Third, customary international law does change, and states can play a role in accelerating that change. Professor Tuvena, in the same op-ed, suggests that states could pass new laws or amend existing immunity laws to introduce an exception to immunity when a foreign state has deliberately violated one or more fundamental norms of international law embodied in the Charter, and the violation has been qualified as such by an organ of the UN. He mentions the Security Council, the General Assembly, or the International Court of Justice. And I would add to that idea of Professor Tuvena that the General Assembly right now has an important role to play because its resolutions can have normative force and can constitute evidence of state practice and opinio juris. And if we had a carefully worded resolution on lifting the immunity or setting aside the immunity of state assets in very specified circumstances, that could signal a change in how the majority of states view the entitlement to immunity in these circumstances, opening the way to judicial, legislative, and executive action in pursuit of resources that would allow Ukraine and its people to rebuild their lives. And I was very interested to hear earlier in this seminar from Mykola Gnatovskyy about the Ukraine Supreme Court judgment finding that immunity cannot be invoked by Russia. So, as I said, state practice can change, and it can move quite fast. Fifth point, states should ensure that they are a hostile environment for war criminals by signing the Crimes Against Humanity Convention to allow for prosecutions of this crime in national courts and better evidence sharing among states, and by expanding national laws to capture more perpetrators of international crimes. And I would just note that, at least in the United States, there's proposed legislation that would pursue this step. Sixth point, the United States should establish a compensation commission. There's various models. There's no model perhaps exactly tailored to this situation, but that doesn't mean that we can't be creative and that we can't build on the best aspects of models that have been tried and tested in the past. And the seventh point, on a human level, states should be extending a welcoming hand to refugees until it's safe enough for them to return home. And we've already seen some really wonderful examples of generosity and hospitality, and also some less impressive examples. And let's hope that the former prevails. So, in conclusion, alongside the refrain that we've heard since Srebrenica and the Rwandan genocide, the refrain of never again, we are now hearing a new refrain. If not now, then when? And this refrain should be meaningful, not empty. And states should consider and adopt proposals and take steps to keep building the momentum towards justice. And we, the International Law Army, should all be helping them to that end. Thank you.
Sorry, I would like to say a few words about the role that international law plays in coordinating behavior. Professor Ko spoke about the fact that many of you, particularly those of you who have been taking part in the Jessup, might have experienced a sense of disorientation as you are, or as you were, working very hard on issues relating to international law, and then seeing more or less at the same time a massive violation of international law. And one might then wonder, well, what is international law for? So let me suggest to you that there are a number of roles that international law plays, and that those roles that international law play continue to be important even in moments where you see serious violations of international law. First of all, international law plays a significant role in legitimating or delegitimating behavior. So this is why you see even the Russian president appealing to international law in his explanation for the actions that Russia is taking in Ukraine. So seeking to justify those actions by trying to claim the high ground of legality under international law. Professor Ko has already dealt with these issues. Likewise, international law plays an important role in legitimizing the actions in reaction to violations of international law. And more importantly, or as importantly, international law plays an important role in coordinating behavior in response to violations of international law. So to the extent that we can see consensus around violations of the rules, then there's a greater chance that we will be able to take coordinated behavior in response to those actions. So where there is disagreement, uncertainty, lack of clarity as to whether or not the initial actions are violations of rules, then you're likely also to see the inability of states to respond in a coordinated way. And I think this is probably what Putin would have been hoping for, a division among states in response. But where there is agreement, clarity about the violations, then there is likely also, or at least it is more likely, that you will be able to coordinate behavior in response to the violations. What I would like to talk about are the consequences of the illegality that we see. And I would like to focus on the legal consequences for other states and the legal consequences for individuals who are perpetrating violations of international law. So if we start with the legal consequences for other states, I mean, how may other states react to this illegality, and what role does international law play in shaping those reactions? Many states have been taking measures to respond, and the question that arises is, what is the legal basis for such reactions? And then after that, I will address the consequences for those individuals who are involved in these violations of international law, and how may individuals be held responsible for violations of international criminal law. Now, the range of measures that states have taken in response to Russian action is very wide and very significant. So we've seen freezing of assets of the Russian state, including those of the Russian Central Bank, freezing of assets of Russian nationals or entities who have a connection with the Russian government, closure of airspace, trade restrictions, and other measures. And how might we think about these measures in response in international law terms? How does international law play a role in providing a framework for this? Now, in some cases, the measures in question fall within what we would characterize as retortions under international law, in the sense that while these measures are in response to violations of international law, the measures themselves are not in breach of any legal obligation by the state that is taking the measure. So while these measures may be unfriendly acts, they are acts which the state concerned has a legal right to take. So this may be the case, for example, with respect to travel bans, because states do not, as a general matter, have an obligation to allow foreign nationals to enter their territory, then it's not in breach to stop them from coming in. With other measures, they may, at first sight, be prohibited by relevant rules of international law, but states might be able to rely on exceptions within the applicable legal regime. So, for example, with respect to trade restrictions that states have taken and are contemplating taking, we have exceptions within the General Agreement on Tariffs and Trade, the GATT, that may be applicable here. And in particular, we've got the security exception under Article 21 of the GATT, which allows contracting parties to take action which they consider necessary for the protection of essential security interests in time of war or other emergency in international relations. So here we have acts which would otherwise be in breach of an applicable legal rule, but they are specifically permitted by an exception to be found in that legal regime. Third, it may be that some of the measures that are being taken rely on the suspension of the relevant treaty. And so even though these are measures that might, again, at first sight, not be in accordance with the relevant provisions of the treaty, international law, and in particular the treaty concerned, may allow for the suspension of those treaty obligations. And then fourth, it may well be that some of these measures that are being taken are in breach of, at first sight anyway, applicable legal rules, but there is no exception within the regime concerned, and so you need to find a justification outside of that regime. And here you get to the notion of countermeasures, which Professor Webb was talking about. So even if some of these measures are on their face in breach of rules, it may be open to states taking these measures to rely on the fact that these measures are taken in response to Russia's violation of international law. Now, of course, to allow in countermeasures, a number of procedural and substantive conditions have to be fulfilled. And also, countermeasures are typically taken by the state that is directly injured by the violation of international law concerned. However, it is clear that Russia's breaches of international law are breaches of obligations erga omnes, so obligations owed to the international community as a whole. They are not simply breaches with respect to Ukraine. And the critical issue with regard to countermeasures here is whether third states that are not directly injured by the unlawful act can take these measures in solidarity with the directly injured state. In this case, of course, Ukraine. Now, the International Law Commission, in its draft articles on the responsibility of states for internationally wrongful acts, was very cautious in the approach that it took back in 2001 on this question. And Article 54 of the ILC's draft article speaks of the right of any state to take lawful measures against the responsible state to ensure cessation of the breach or reparation in the interests of the injured state. And that reference to lawful measures was precisely to avoid making a judgment as to whether countermeasures were permissible when taken by third states not directly injured. At that time, the ILC referred to the embryonic state practice in this regard. However, I would suggest that since the ILC's articles were completed in 2001, there has been significant increase in the practice of third states taking measures in response to violations of obligations erga omnes. And it seems to me that the time has now come to end that debate and to acknowledge that third-party countermeasures are indeed permissible in response to violations of obligations erga omnes. And it's also probably time for states to start to state this explicitly. Let me now come to the issue of accountability for international crimes and take just a little bit of time on this before I turn it back to the moderator. There are two questions that arise here. Number one, what are the mechanisms for achieving accountability? And number two, over what crimes? In terms of the mechanisms for achieving accountability, there are three options. First option is prosecution before an international tribunal, like the ICC. The second option is prosecution in the domestic courts of Ukraine. And the third option is prosecution in the domestic courts of foreign states in the exercise of universal jurisdiction or other extraterritorial jurisdiction. And with respect to what crimes? Well, war crimes, crimes against humanity, possibly genocide. But I want to say a little bit about the crime of aggression. The International Criminal Court has these four crimes within its jurisdiction, but in this particular case, the ICC is not able to exercise jurisdiction over the crime of aggression because Russia is not a party to the ICC statute, and also because any attempt by the UN Security Council to refer the situation relating to Ukraine and the crime of aggression to the ICC would, of course, be vetoed by Russia. And so a number of people and states have taken the initiative to propose the creation of a special tribunal to deal with the crime of aggression against Ukraine. And Professor Gnatovskyy has already spoken about this. Why is this important? Why should we be putting energy into this? The first thing, and this is just to underline what Professor Gnatovskyy said, is that the crime of aggression was described by the Nuremberg Tribunal as the supreme crime. The Nuremberg Tribunal said that it contains within itself the accumulated evil of the whole. Everything that we are seeing now in Ukraine follows from the crime of aggression that was committed against Ukraine. And it's important to underline that. Secondly, it is probably easier in this scenario to establish the criminal responsibility of senior leaders for the crime of aggression than it would be to establish responsibility for individual war crimes or individual acts that might amount to crimes against humanity. Because aggression is a leadership crime. It's about the decision to wage the aggressive war in the first place. It's one which is located exclusively within the realm of senior leadership. I know we're fast running out of time. Maybe I will turn it back to Jess. There are a couple of other questions that might arise here, but perhaps we might deal with this in Q&A. For example, why are we seeing an emphasis on accountability in this particular case, where we might not have seen it, for example, in other cases? But let me turn it back to Jess, and we can move into Q&A.
Thank you very much, Professor Akande, and thank you to our other speakers. And I actually want to pick up on exactly that question and perhaps direct it to Professor Ko. And it's sort of a two-part question, I guess, and it's a little bit difficult or indelicate. Some of our friends in the Global South and elsewhere have asked why this conflict is getting so much attention when there are other conflicts and situations where atrocities have been committed that have been largely ignored by the international community. And so I'd love to hear your response to that question. And then similarly, picking up directly on what Professor Akande was just talking about, why is there so much talk about accountability mechanisms for this conflict when similar efforts have not been made for other conflicts? For example, you can think about the UK and the US actions in Iraq and Afghanistan.
Well, I think this is obviously a case that's very close to the bone for those countries that were responsible for the post-war legal order. It's happening on the continent of Europe, and to places where people have traveled, have relatives live nearby. So, and the refugees are showing up at their door. So I think that there's a sense in which the shock value of something happening right next door is greater than in some other cases. I don't think the solution is to de-emphasize this conflict. It's to get more focus on the ones that have been ignored, frankly. And I think that to say that this conflict is getting too much focus is probably the wrong way to go about it. I also want to emphasize that there is something extremely unusual going on, which we should note as international lawyers, which is this is a campaign of aggression, naked aggression, unapologetic, committed by atrocity. They didn't have to use the atrocities to do the aggression. In fact, in 2014, the Russians did many things to disguise their efforts both in the Donbass with little green men and the phony referendum in Crimea. This time, it's just blatant and in your face, as we say in the United States. What this means is we have a campaign of indiscriminate shelling from afar. Namely, Russian military forces are just bombing civilian targets without any effort at distinction, essentially ignoring the laws of war, which so much time and energy has been put into developing and defining. And then secondly, what Bucha and other things show us is that when they get close up, it's just face-to-face brutality of the most naked kind. People are being tortured. They're being bound and shot in the head and thrown into mass graves. And people who obviously are civilians. And we have stories told about buildings that are labeled children and they're bombed anyway. So the real question, I think, is can this kind of blatant, naked violation of international law without apology go uncorrected? And I think that's what's giving the focus to accountability. I think the obvious question is we have accountability mechanisms that have been underperforming. And the question is, do we need new accountability mechanisms or should we focus on making the existing wheels work better? But I think that every situation demands its own accountability process, and we should be gathering the kind of evidence that we need every single day, because the war crimes are mounting, the reparations costs are mounting, and we need to know all of these. This is a lot of work for a lot of people, and I assume that the people who are watching this webinar are interested in finding their place in doing this kind of important work. There will be national prosecutions, there will be international prosecutions. There will be, this is a kind of seminal event that will drive the world of public international law for 30, 40 years. And I think nobody on the call will go untouched by what's happening in front of our eyes right now.
Hi, Jess. Maybe I can just come in on this issue as well. I mean, I think, people are right to be concerned about selective application of international law. We all want international law to be applied equally. However, I think there are some significant differences between what's happening now and some of the other situations that sometimes people point to with respect to accountability. And probably the most significant difference is that this is a situation where the state on whose territory these crimes are being committed wants there to be accountability for the commission of these crimes, is actively seeking accountability for these international crimes. That was not the case in Syria. That's not the case in Myanmar. That's not the case in some of the other situations that people sometimes point to when they say, why hasn't there been accountability in these situations? In many of those cases, the reason why there hasn't been accountability is actually largely because the governments of those states actively oppose it, as opposed to this case where the government of the state where the crimes are occurring is looking for mechanisms to achieve accountability. So, and I think it's important to bear that in mind. Secondly, it's not that long ago, actually, that with respect to the ICC in particular, there was, people were saying, look, how come all the prosecutions are only taking place in Africa? How come all of these issues are only taken in the global south? And there were a number of us who were sort of working very hard to try to say, well, international criminal justice is actually not just for Africa. International criminal justice is not just for the global south. And now there seems to be the reverse, to say, well, why is the global south being ignored? And I think the reasons are what I have just said. The final thing that I will say, though, and I think this is sort of underlining the point that Harold was making, which is to say, we need to do a lot of work actually to ensure that in other similar cases, we will have a similar reaction. And also, I think it's incumbent on the states that are taking action now to ensure that their responses remain consistent. And I'll just point to two things where I think we need to remember actually the responses of states now, and for the future, it would be important for those responses to be consistent. So one area is on the question of the jurisdiction of the ICC over nationals of non-parties. This is something that the United States has in the past been opposed to, whereas at the moment, the US seems to be in favor of. And I think it's important that actually that remains consistent, that stance remains consistent for the future. And the second one is on the extraterritorial application of human rights law, particularly in situations of conflict. So if we just take within Europe, a number of states, the UK in particular, France and others, have taken very restrictive views about the extraterritorial application of human rights law, particularly in situations of conflict. But at the moment, they don't seem to be taking such a restrictive view. And so again, if they are to be consistent for the future, they need to ensure that what they do now, they don't step back from what they do now, but they continue to maintain the same stance if similar situations arise going forward.
Thank you. Professor Webb, I think everybody has mentioned the Security Council and the role that it is playing or perhaps not playing in this conflict. So I wanted to pick up on that. First of all, I was just wondering if you could explain a little bit more of what an ARIA process proceedings are for those in the audience that might not be familiar. And then secondly, if you could address this sort of bigger question of course, we know that Russia is a permanent member of the Security Council and can veto any action directed towards it. So what does this tell us about the future of the Security Council? Will this war affect the veto right of the current 5 permanent members? Is there any prospect for any expansion or reform of the council, particularly coming off of what we're seeing right now?
Thank you, Jess. So first on the ARIA formula, this is a meeting that's an informal meeting. This is an informal meeting of the Security Council, and what an important feature of it, and that was very apparent in the meeting on the 27th of April, is that it can include a range of participants with a particular focus on civil society. So we had Amal Clooney from the Clooney Foundation for Justice and the Legal Task Force for Accountability. We also had Human Rights Watch actually joining. Well, we had the head of Human Rights Watch in the room in the UN, but we also had their representative joining directly from Ukraine and speaking directly to the member states. So it's a formula that's been used more and more often to bring in the voices of civil society and to ensure that council members and also non-council members, General Assembly members, are getting as full a picture as possible. On the prospects for the council and the veto, I have to say I don't see any formal change happening. The Charter, and in particular the composition of the Security Council and the allocation of the veto to those 5 permanent members, was very well considered in San Francisco. It was very deliberate. It was built into the design of the council that it would result in a deadlock through the use of the veto. And that's what we've seen happen in this case and also in previous cases such as Syria. To amend the charter to change that in some way would require, among other things, all permanent members to agree to the amendment. So again, by design, they're not going to give up their veto, and certainly Russia is not going to give up its veto. So we have to work within the system that we have, the legal framework that we have, and there are still options there. So under Article 27.3 of the Charter, a veto-wielding member of the council is required to refrain from using that veto if a resolution under Chapter 6 pertains to a dispute in which they are involved. This has not always been honoured consistently in the past, and I fully endorse what Dapo said earlier about steps that we take in this situation should be the same steps that we take in future situations or parallel situations. So Article 27 should be respected, and any resolutions under Chapter 6 should not be subject to the veto of Russia. And there's quite a lot that can be done under Chapter 6. Obviously, it's not the coercive action under Chapter 7, but there's still quite a lot of options, including in relation to accountability, possible compensation commissions, and so on, that could have a Chapter 6 route. The other option that we've seen is the revitalization of the General Assembly as the kind of conscience of the UN in this situation. And that's also an avenue to explore what the UN General Assembly can do through its resolutions, which, while technically recommendations only, we know have potential force in creating and reflecting customary international law. And then finally, we also can look beyond the UN to regional bodies, regional organizations. We've already seen strong action being taken by the Council of Europe.
Jess, could I just add to everything?
Please.
Agreeing with everything Philippa said. As the old person on the panel, when I was first studying international law, the Russians vetoed many things. And a lot of what international lawyers did was figure out ways, creative ways around the Russian veto. The Uniting for Peace resolution of the General Assembly, which allowed UN intervention in Korea, was a result of getting around that veto. I was interested to see that when I was a young law professor in the 80s, and Gorbachev's famous speech about the new realities and guarantees of international law, that because it suddenly seemed possible that the Security Council could function as intended without vetoes, a lot of young international law professors became formalists about this, and frankly kept saying, if the Security Council doesn't vote, we can't proceed. We saw the consequences of that in Syria, when 13 consecutive vetoes led to the slaughter of Syrians, and when, as Dapo pointed out, the Syrian leader's unwillingness to consider any sort of check on his brutality or to consider accountability left a lot of these people abandoned by the Security Council. So I think what this is now calling for is a revival of the kind of intellectual creativity that international lawyers had to display in the Cold War period to have a dysfunctional organization still be effective in the worst situations. And finally, just to follow on something Dapo said, which I think is very important, Philippa put it well: if, now, when. When people in the global south say, well, they didn't do anything with regard to other gross violations, so why should we do so much here? Well, the answer is, if not now, when? We're seeing violations at a very blatant and flagrant level. International law functions the worst in guaranteeing equality of treatment among the rich and the poor and the people of the North and the South. On the other hand, it is a precedent-driven system. And so it may well be that there's a demonstration effect from a powerful response here that could redound to the benefit of these other parts of the world in current crises and future crises. And again, that's a moment of creativity for international law that we ought to all encourage everybody on this call to think about going forward.
Thank you. Professor Akande, you mentioned, you talked some about sanctions, and I wanted to follow up on a few of the things that you mentioned. So since the invasion in February, a whole host of sanctions have been imposed against Russia. And those sanctions seem to be aimed at crippling Russia's economy and impacting powerful players within Russia. But they're also having a very severe impact on individuals. Is there any kind of proportionality consideration that goes into the imposition of sanctions vis-a-vis the civilian population? And then I also wanted to hear your thoughts on sort of how those sanctions are increasing and changing. This week, we've seen the European Union move to place sanctions upon Russian oil, which is a position that seemed pretty untenable even just a few days or weeks ago. And so what has changed, and what effect might that have? And might those sanctions not actually be pretty damaging and detrimental to the EU and individual states? And so how are states thinking about sort of balancing action, punitive action towards Russia and the impact on themselves?
Thank you. So on the first issue, the sort of human rights implications of sanctions, or even just more generally, the sort of legal constraints that might apply with respect to the imposition of sanctions. So as I was saying, and Philippa talked a little bit about this as well, international law has a framework for considering measures that are taken in response. So Philippa talked about the immunity issue, and we can divide sanctions here into two. We can talk about sanctions that are being imposed against the Russian state and state assets. So particularly if we're talking about asset freezes. And Philippa set out there the sort of possible constraints that we might think about, and actually the ways in which these may not be constraints, sort of how to get around those constraints, particularly with respect to the question of immunity. Then you have sanctions that are imposed on individuals. So the sanctions that we've seen on oligarchs and the assets freezes on those individuals. And there, you have two things that you need to think about as far as international law is concerned. So you have human rights considerations, and you have actually also considerations that might exist under bilateral investment treaties to the extent that those sanctions are affecting investments by those individuals. With respect to the human rights matters, there might be a number of human rights questions that one might think about, so a number of human rights obligations that one might be thinking about. So in the European context, the European Convention on Human Rights, you might be thinking about right to peaceful enjoyment of possessions, right to respect for one's home, right to a fair hearing, those kinds of things. The important thing to note, though, is that none of these rights are absolute rights. And so because they are not absolute rights, it means that states may take measures which actually impinge on the exercise of those rights, where this is done for the pursuit of a legitimate purpose, and in circumstances where the measure that's been taken is proportionate to achieving that purpose. Given the scale of the illegality that we've seen, it's probably going to be easier in this circumstance to satisfy the proportionality requirement. And so, yes, there are human rights issues to think about, but the framework that human rights law provides for is one that I think will, in many circumstances, allow for the imposition of these measures because of the scale of the breaches that states are responding to. Now, the more general question of, the impact of sanctions on the population of the states actually that are taking the measures, I mean, that's probably less of a legal question and more of a political question. And of course, I suppose the reality is that responding to aggression is not cost-free. Whatever way in which we're going to respond to aggression, it's not going to be cost-free. So it's certainly not cost-free for the Ukrainians who are bearing the large brunt of it, actually fighting. And it's not going to be cost-free for other states as well. And I suppose the hope is that states will be prepared actually to bear that cost in order to bring to an end these violations that we are seeing.
Can I just chime in, Jess, that agreeing with everything Dapo said, what's being flagged here is not just the Ukraine crisis, but two other great human rights crises of our time, namely climate change and global health. Why should it be that Russian oil has this kind of leverage on the world? Or for that matter, Mohammed bin Salman in Saudi Arabia? Or why should it be that the consequences of inflationary pressures because of sanctions makes people want to revisit whether they should isolate Venezuela with sanctions? To me, these are more signs and more proof that we need clean energy, broadly distributed and produced, and not in the hands of autocrats who just happen to have seized control of countries in which fossil fuel resources are in the ground, which are destroying the future of the next generation. And on global health, you have China, which clearly, by all scientific accounts, through zoonotic disease generated in Wuhan, caused the last pandemic, kept people out, and prevent the World Health Organization from doing a serious investigation, and has now responded to a resurgence of COVID within China by trying to use its autocratic powers to lock down and sort of shut off the country and impose mandates throughout, which autocrats are able to do. But with not taking, as far as we can tell, real steps to prevent the next pandemic. And it's, flowed and affected every single human being on this planet. So I think we shouldn't lose sight of the fact that the human rights crises that we're seeing in Ukraine flag and underscore the importance of addressing these two other great international law challenges of our time: how to, get to multilateral solutions, enforceable solutions on climate change and on global health security.
Thank you very much. And thank you, Professor Ko, for drawing those connections between those other challenges, climate change and global health. It's really important to think about sort of the patchwork of issues that we're dealing with here. Professor Webb, we're witnessing the largest refugee flow in mainland Europe since World War II. And refugees that are coming from Ukraine are being treated very differently than Black and brown refugees and that we've seen entering Europe from a variety of crises over the past decade. What does that tell us about racism embedded in the refugee system? And a separate but related question, is it likely to be any kind of burden sharing between states? So are there likely to be any funds flowing from those that are less affected by refugee populations directly within their borders to those who are more directly affected to help support these refugee populations?
Thanks, Jess. Yes, you're right. We've seen an uneven response, both in terms of how the refugees flowing out of Ukraine have been treated, as opposed to refugees from, for example, Afghanistan. And we've also seen a difference in the response of various states to the Ukrainian refugees. Yes, some of this is racism. I mean, it's undeniable. It's a system where immigration is a hot election topic, a hot government topic in many countries, including the country I'm from, Australia, where different political parties feel they have to take extreme positions in order to secure the electorate. And that makes it very difficult to shift from that position when we have a sudden humanitarian crisis like this. So we see here the interaction of, domestic politics and international obligations. I think what it also exposes is, despite the great achievement of the Refugee Convention in 1951, and the great work of the UN High Commission on Refugees, it is sort of scrambling to keep up with the type of refugee flows that we see today, but also potentially in the future. And this relates to Harold's point about how, these crises are interconnected. We are already seeing flows of people escaping the effects of climate change and massive displacement that is inevitably going to increase over time. And that's not something that the 1951 Convention envisaged or really addresses properly. But the positive and optimistic aspect is that we have seen states like Poland be incredibly generous and without hesitation. We've also seen, I've seen this in the UK, despite a government taking quite a delayed and limited response, we've seen individual people opening up their homes, driving trucks and buses to, for days across borders. So we've seen civil society and individuals stepping into the gaps left by government inaction. And I do think some kind of burden sharing may be the sustainable and practical way forward, but not one that sends a selected group of refugees to another continent. And I would point to the UN High Commissioner for Refugees just recently launching a regional refugee response plan, which is trying to take a more sort of holistic approach to the projected 8.5 million refugees in Hungary, Moldova, Poland, Romania, Slovakia, Belarus, Bulgaria, and the Czech Republic to support those states that are receiving these refugees. But for that, they need other states, including Western and well-developed states, to fund. They're asking for $1.85 billion in the first round. So maybe the burden sharing is not going to be about shifting refugees who come to your shores on a plane to another continent, but actually some states being able to step up those resources to enable the neighboring states to properly accommodate these people who are facing such dire conditions.
Thank you very much. I'm very mindful that we only have a few minutes left. Professor Akande, Russia is a nuclear power. What monitoring efforts are being undertaken to ensure that Russia does not utilize nuclear weapons and in order to avoid any escalation of the conflict?
I mean, this is one of the things that makes this conflict so serious and so dangerous, because we have an act of aggression by not just actually by nuclear power, but also by nuclear power that has hinted that it might actually be willing to use these weapons. I have to be candid and say I don't know what efforts are being taken to monitor that use. But despite the fact that we're seeing aggression by nuclear power, one of the things that I think is important is that aggression is still actually resisted. I think it's important to show that just because a state possesses nuclear weapons doesn't mean that the rest of the world is unable to take action to respond to that use. Of course, we all sort of hope that we're not going to break that nuclear taboo and that there won't be a crossing of the line with respect to that. But at the same time, it's very significant that states are not being coward and, that states are not refusing to take action simply because Russia is a nuclear power.
Thank you very much. I wish we had more time. I think we have many, many issues that we have not had time to touch upon and will not have time to touch upon, unfortunately. Professor Ko, perhaps I could invite you to sort of close things out by talking a little bit about what the international legal community, and particularly law students, can be doing in this moment and thinking about how to use the capacity that they have to help.
Yes. Well, one thing I've seen, and I'm sure Dapo and Philippa have seen it as well, is that there are moments where you think international law is so challenged that it's powerless and useless, and you wonder, why did I spend my time studying it? But at the same time, you suddenly see that there are opportunities for imaginative international lawyering to get around problems. Philippa was just mentioning, for example, the problems of stalemates in getting treaties amended, the UN Charter almost impossible to amend, the impossibility of fixing the Refugee Convention to expand it beyond its 1951 bases of persecution. And it means that there's going to have to be interpretive imagination by international lawyers to modernize and translate the spirit of these laws to the 21st century. My late Yale Law School colleague, Bob Cover, called this juris generative moments. And we should recognize we're in one of those moments now. Philippa gave a good example. Are we stuck with a rule where a country can commit aggression and war crimes and then say that its assets should be free to move around because of doctrines of sovereign immunity? Or can we be creative and figure out ways in which these assets can be immobilized and tapped into for the country that needs reparations for the crimes that this aggressor nation is committing? And I think this is therefore an important moment for every international lawyer, young and old, to think about ways in which they can contribute. They can advise companies not to invest in Russia. They can work in international organizations. They can work for NGOs. They can work on various forms of dispute resolution that didn't exist a long time ago. You don't have to go to the International Court of Justice to make these kinds of international law arguments. And in those settings, be creative. Offer imaginative interpretations which make your point. And this is to resist the notion that international lawyers are just scriveners filling little gaps while power and force determine the architecture of the world in which we're going to live. Back in the Bretton Woods, San Francisco period, international lawyers were the architects, and they were the ones who helped design the framework in which power and policy could function, but were also constrained by different kinds of rules. And so I think that this is a moment to think very creatively, as your Jessup students thought creatively in how to make their arguments for the purpose of prevailing on behalf of their clients in this global competition. And there is a global language of international law, which is epitomized by the Jessup, and the Jessup participants will be playing that role for the rest of their lives, and I hope a very productive one.
Thank you, Professor Ko, and thank you to each of our panelists for sharing their time. Thank you to all of you that submitted questions, that attended this event live or are planning to watch later. For the students on this call, please join the international law army that you've heard so much about today. Seek out opportunities to help those affected by this war by donating your time to support those seeking asylum. Find ways to get involved in some of these accountability efforts that you've heard about today. I would encourage anybody that is able to donate to organizations that are supporting on-the-ground assistance for those in Ukraine and for those that have already fled. And please do engage with politicians in your home countries to get them to exert whatever pressure they can to bring this conflict and the atrocities to a close. Ukraine is going to need all of our help to rebuild, and they're going to need our help, our support for some time to come, and all of us need to play a role in that. So thank you so much to everybody for joining this conversation.